Good morning, friends. It's wonderful to have you here this morning for this hearing by the Utah Court of Appeals. The Utah Court of Appeals is the second highest court in the state of Utah and is a court of general jurisdiction, which means they can hear just about anything, but they are an appeals court, which means that the vast majority of cases, if not all that they will hear, are cases that come to them on appeal after having been heard in a trial court. In Utah, we call those our district courts. And so for the vast majority of legal matters that are based solely on Utah law, this court is going to be the last stop. Only a handful of cases that go on to the Utah Supreme Court will have hearing beyond this. And the only way you end up in the U.S. Supreme Court or the federal court system is that if the hearing involves some matter of federal law or the federal constitution rather than being based only on state law. So this is a really significant group. We're very fortunate to have them on campus and appreciate their dedication to outreach and education as part of their mission. I will quickly introduce the judges and then I'll step off the stage so that court can properly be declared in session in the absence of any extra people like me. So first I'll introduce Judge Ryan Harris. Judge Harris is the Associate Presiding Judge of the Utah Court of Appeals. He was appointed to the Utah Court of Appeals in June of 2017. Prior to his appointment, Judge Harris served as a trial judge in the 3rd District Court for nearly 6 years, where he also served as the Associate Presiding Judge. Judge Harris twice received the Judicial Excellence Award from the litigation section of the Utah State Bar, and he graduated magna cum laude and with university honors from Brigham Young University in 1995, followed by graduating with distinction from Stanford Law School in 1998. Judge John Luthi will be chair of the panel today. This court has a larger number of judges, but hears their cases with rotating sets of 3-judge panels, and Judge Luthi will administer the panel today in his role as chair. He was appointed to the Utah Court of Appeals in October of 2022. Prior to his appointment, he served 3 years in the Cache County Attorney's Office, first as a civil deputy county attorney and then as the county attorney. Judge Luthi graduated magna cum laude from Utah State University in 1996 and cum laude from the J. Reuben Clark Law School at Brigham Young University in 2000. I should also mention, because I know we have some Skyview High students here today, that he graduated from Skyview High prior to pursuing these other matters of education. Prior to his service as a judge and in the county attorney's office, Judge Luthi was on the faculty at the University of South Carolina School of Law, where he taught legal analysis and writing. Finally, the 3rd member of our panel today is Judge David N. Mortensen, who was appointed to the Court of Appeals in 2016. Prior to his appointment, Judge Mortensen served as a trial judge in the 4th District Court for almost 10 years, where he served multiple terms as presiding judge and associate presiding judge. Judge Mortensen graduated from the J. Reuben Clark Law School at Brigham Young University in 1993. Judge Mortensen received the 2016 Distinguished Service Award from the Government and Politics Legal Society of the J. Reuben Clark Law School. I'm happy to have your company here as we get the rare and unique opportunity to watch this court in session. Thank you for being here. I would ask that you each silence your phones if you have not already done so, so as not to disrupt the court proceedings. If you need to come or go during the course of the proceedings, we ask that you wait until between the 2 cases. There will be 2 cases heard today. Each will take about 45 minutes, so if it's at all possible to wait to come or go for in between the sessions, we ask for your cooperation on that. Following the second court session, the judges will engage in a question and answer period with those who are able to stay. So if you're watching through the case and you say, that was really interesting, I'd like to know more about that, or you just want to know more about being a judge or the legal system, that's a moment to ask those questions. I will have to say, for ethics reasons, The court will not answer questions about these cases specifically. So if you say, well, what did you think about this argument? The judges can't answer that question because they have to stay unbiased until they've completed the process of the hearing. But the Q&A is usually one of the best parts of these kinds of events. So thank you for being here, and we'll turn the time over to the court for the duration of the proceedings.
Thank you. It's a pleasure for us to be here on the Utah State University campus and to hold court. And for this morning, this is a courtroom, and we appreciate the decorum you've already shown as you've been here. We know we were introduced before we came out. My name is John Luthi. I am originally from here in Cache Valley, and I'm so glad to be here again in this capacity. I am a Bobcat and an Aggie and a Cougar all at once with my different levels of education. Glad to be joined by Judge Mortensen and Judge Harris. Before we begin, I'd like to thank Dr. Can. He and I were neighbors for a time, and he's a good man. He's representing the School of Political Science. We know that we're also hosted by the College of Arts and Sciences and the Department of the School of Social Sciences, and we thank Dr. Finley and Dr. Ward. Also Jennifer Seelig, who helps us as we go around the state and hold these events at campuses around the state. She's the director at the Institute of Government and Politics. We also recognize Nathan and Laurel Alder and Sherry Sedgwick, who have helped sponsor and help put these things together. We also recognize the folks that do the facility here. This is a great facility on campus, and the people that keep it up and host us are wonderful. We appreciate campus police and our own trooper who provides security. We want to talk a little bit before we begin about the process. We are Utah's intermediate appellate court, and you'll see here today we don't call witnesses. That's happened in a trial court. We're here to hear legal arguments. The party who did not prevail in the trial court can appeal and come before this court with legal arguments as to why maybe charges should be dismissed or a new trial be held. Before these oral arguments, the parties have all provided us legal arguments in writing, in briefs, and we have read those arguments and are familiar with them, but we have questions. Today, this panel will be considering 4 cases, and we'll be hearing oral argument in 2 of them. Not every case gets oral argument. About half of our cases get decided just on the briefs. So in these cases where we do hold our oral argument, we have additional questions that we'd like to ask the attorneys. We're a court that has 7 members, and we sit in panels of 3, as you can see today, and we just rotate through those. We run on a time clock. Our attorneys, and as we mentioned the attorneys, we want to thank them for coming and being here with us today. We know that the travel is not ordinarily this far, and so we appreciate you being here. And you will see good counsel argue today. We are on a clock. Each side gets 15 minutes, and the appellant gets to go first, and the appellant gets to go last, because they have the burden of persuasion, we call it. And so our appellant's counsel, it looks like, has reserved 3 minutes for rebuttal. We'll ask our counsel, as you come to the podium, to make an appearance. And the first case that we'll be hearing today is our case number 2024-0207, State versus Qayum. Am I pronouncing that correctly? Okay. Unless counsel has questions, we're ready to proceed.
May it please the court, Natalie Skabine on behalf of the defendant, Mr. Qayum. We've raised several issues in this case. I hope the court asks any questions it has about any of our issues, but I was planning to start with the destruction of evidence. Guilt in this case depended on two things: that Mr. Qayum believed the woman in the dating profile was 13, and that using an adult model did not create a substantial risk of that the offense of soliciting a minor for rape of a child would be committed by one not otherwise ready to commit it. If the dating profile showed a woman who could not reasonably pass for 13, the state had a much weaker case on both fronts. The state destroyed the profile it used to attract Mr. Qayum and the only photograph he had seen at the time he solicited the woman in that photograph. The court was wrong that there was no reasonable probability that the lost evidence would have been exculpatory.
There was one photograph that showed who he thought he was chatting with in a red dress, is that correct?
That's right, and that shows us that there's a reasonable probability that that initial profile photo would have been exculpatory, because we know that that was an adult woman. She was at least 18, and that was what was proffered at the time of the pretrial hearings. At trial, the officer said she was right around there, could have been 19, 20, and we know from that photo that she did not look 13, but we don't have the photo that he saw at the time that the solicitation occurred. So defense counsel did his best with the photo available, put that one up for the jury, said, here's the minor, she doesn't look like a minor, but that wasn't the photo that he saw, the most important photo in this case, because that was sent at the time that he was already driving to meet her. And the entire context of the text messages changes based on what did the photo look like. Because as counsel argued below, people mess around on the internet, they role play, they play along. If he shows up and he's really skeptical but just curious, that is something short of proof beyond a reasonable doubt that he believed that she was 13.
Was a full copy of that red dress photo put into the record?
So what we have is the exhibit where the officer is scrolling through, it's a video exhibit, scrolling through the entire text message change and blows that one photo up. And then we know from reading closing argument that defense counsel talked about that photo.
Okay, yeah, so there's not only, as I understand the record, there's not only the video of what the officer's body camera caught, but the actual print copy of the text exchange was also entered into the record, right?
Right.
And that has within it more than a thumbnail. It's it's bigger than a thumbnail, but not full size of the red dress photo, right?
That's the one photo that we know that defense counsel at least received a full copy photo of. But again, that was the least important photo in this exchange because it was the last one sent. The angle is kind of down, it's a little bit blurry. We know from it that there's a reasonable probability that any photo of this woman would be exculpatory, but it doesn't show us enough to know what that initial photo would have been.
In meeting that burden, it seems to me that the person who saw both the red dress photo and this other photo would have been able to tell us, your client could tell us if they were materially different. He could say, yeah, that's way different than this other photo. That would enhance our ability to say that it was truly exculpatory. Do we have that anywhere in the record?
We don't need it. All we need is a reasonable probability that it would have been exculpatory, and that's a low threshold. So in De Jesus, even though the court did not find the witnesses credible when they said that the video would have shown something exculpatory, there was still a reasonable probability based on their testimony that it would. And here we don't need his testimony.
My point is that if we already have the picture of the red dress and the jury looked at that and took that all into account, don't we have to believe that there's some probability to be truly exculpatory that it would have made some sort of difference had both of the photos been in evidence?
Well, it would have made a difference for two reasons. One is the jury would have thought, well, maybe when he saw this last photo as he's driving there, he would have thought, oh, she looks older, but the defense counsel wasn't able to say, here's the bare text messages, and these completely change when you look at this photo, and this is who he's talking to. Now it looks like he's role-playing. Now it looks like he's playing along. Now it looks like he must at least be deeply skeptical that this is a 13-year-old. So it's important to have the profile photo itself. And then what we know from the later photo is that the profile photo would have been exculpatory. And we don't know exactly how exculpatory it would have been, the same is true in De Jesus, but there's at least a reasonable probability that when it's an adult, when she doesn't look like a 13-year-old, that photo would have been exculpatory.
So, I mean, let's go kind of down to first principles a bit, and maybe I can ask you, what evidence can you point to in the record that indicated that your client actually thought she was older than 13? I mean, when you look at his initial response to learning that she was 13, he says, oh, you're very young, we can do it, but we have to be very careful. He doesn't express any skepticism about her claim that she's 13 in the texts. And then when he's arrested afterward and interviewed, he likewise doesn't appear to express any skepticism that she was 13. So what can you point to in the record indicating that he actually thought that based on this photo that he saw that apparently isn't in the record anymore?
So counsel's argument below was the photo that we have, the photos that we have, either the cropped thumbnails from the chat or that final photo in the red dress, show a woman who does not look 13. And that completely changes how you read the text messages themselves. And then counsel's other argument was people mess around on the internet, people role play, and people might be skeptical about what they're reading from someone else, but they're not going to call them out. They're going to be curious. They're going to want to find out. So that was enough to show a reasonable probability that this photo would have been at least exculpatory and also just very important to how counsel could argue this case below.
And counsel argued below that he didn't know that she was 13.
Yes, counsel made two arguments below. He did not believe that she was 13 based on the photo, using that later photo, which again the jury would have thought, well, he didn't even see that photo at the time he made that initial solicitation, and then also entrapment, that the use of a model who does not look 13 with the reveal after a deal has already been made is entrapment.
But you're not challenging that finding, or in your challenge to the denial of the directed verdict motion, you're not challenging his knowledge that the motion should have been granted based on that, correct?
Yes, going to our first issue, which is the directed verdict motion and the ineffective assistance of counsel claim there, we've focused our arguments on entrapment in that instance, but for the destruction of evidence, for the due process argument, this evidence was important to both claims, and both claims were before the jury. And the court realized that the photo was important. It mentioned the photo twice in its ruling and kept saying defense counsel has been provided the photo. But the court was wrong that there was anything useful in that circular thumbnail that only showed hair. So the court recognized it was important, but it was wrong that the photo that the state produced for defense counsel was useful.
Yeah, I think everybody's in agreement now about which photos were in possession of everybody below, right? The thumbnail of the original profile photo, and then the slightly bigger photo in the red dress. Those are the two photos that we have, right?
That's right.
So there's no need to talk about the Rule 23B motion then, right? That's sort of been taken care of through the briefing, right?
I think that's right, through the state's concession. But I think it's noteworthy that the district court kept saying the state has produced the photo, so it seemed to understand the importance of the profile photo, not the red dress photo. But there wasn't anything useful in that thumbnail photo. There's no face, there's no body, there's no way for counsel to argue she doesn't look 13. He didn't believe she was 13 based on that thumbnail photo. The degree of culpability for the destruction of the evidence was higher in this case than in De Jesus. In De Jesus, the state was negligent when it failed to preserve prison surveillance video. That was on a system that did not save it after 30 days, whereas in this case, the state seems to have intentionally destroyed the profile photo. And then the final consideration is prejudice to the defense. And in this case, the photo was critical to argue that Mr. Qayum did not believe the woman was 13 and that the state induced the offense by using a model who did not look 13. I'd like to spend the last few minutes on the Miranda issue. Mr. Qayum, after hearing his rights and being asked if he understood them and could tell the detective so, said, "I have to tell my attorney to talk to you to answer my questions." This was an unambiguous invocation of the right to counsel. In the context of having just heard his rights, he expressed a desire to deal with the police through counsel, and he's nervous, he's speaking to an authority figure, but the words he used were an invocation of the right to counsel.
So the district court, when the motion to suppress came up, interpreted those words differently than you're interpreting them now. What's your view on, do we give any deference to the trial court's interpretation of those words, or do we review this de novo?
No, because it's on a video, our courts have said that there's no reason to give deference to what the district court thought when it watched the same video that this court is going to watch. So if there are any factual findings that involved credibility, for example, there would be deference, but in this case we don't have anything like that. All we have is the video, that's all
And here the video itself is actually in the record, as I understand it.
That's right.
It's not just the transcript of it, we actually have the video. So, and I noticed in going through the record, there was 2 or 3 different ways that your client's key sentence has been phrased in various motions and orders and things. So to the extent there's any, I guess, ambiguity about what was said, we can go back and watch the video and make our own determination based on what you're telling me here about what was said and the tone and all of that, right? Because we're reviewing this de novo.
Yes.
Okay.
Yes, and under Smith, the fact that Mr. Qayum continued to answer questions cannot be used to cast doubt on his invocation and whether it was unambiguous when it was made. And then just finally, the state's alternative argument and what the court believed. If Mr. Qayum was trying to recite his rights back to prove he understood them, what he said proved that he did not understand his rights. And if there are no further questions, we'd ask the court to reverse.
Thank you, Ms. Kameen.
Emily Saab for the state. First, there is no reasonable probability that that missing profile picture is in any way exculpatory. To show a reasonable probability, Qayum must show that something more than pure speculation. And all we have is speculation. That was all that was presented below. It's all that's been presented here today, that this picture could in some way affect the overall evidence in the case against Qayum.
I mean, what would it take, hypothetically, for this photo to have a reasonable probability of being exculpatory? A photo of a obviously 65-year-old woman?
That could possibly be, if even a proffer that it was a 65-year-old woman, testimony from Qayum that it was a 65-year-old woman, something that shows that there's no possible way he could have believed she was 13.
I mean, conceivably, you could think up some facts where that photo could, in fact, be exculpatory, right? I mean,
yes.
So it's not that it's impossible. What you're saying is it's just not reasonably probable?
It's not reasonably probable, and Qayum hasn't offered those facts. And he must offer something more than pure speculation or something wholly incredible. And that she is an 85-year-old woman would be wholly incredible here. Not only do we have 2 photos of her, we have 7 photos of her in the record.
Help me understand that. I thought it was just the 2.
No, in the text exchange, we have a video scrolling through, and you can see 7 photos of May.
But none of those have her face in them, right?
No, they do have her face. I don't know exactly how many, but at least 3 or 4 have her face in them. They're not blown up for the jury, but they are scrolled, and you can clearly see her face in the exhibit.
Okay.
Additionally, we have a profile photo of Qayum. If you look at the very beginning of the exhibit, we have a blown-up profile photo of Qayum, and you can see how that was shrunk for the thumbnail. The edges were minimally cropped and shrunk, and you can assume, or we can infer, that the same thing occurred with May's profile photo, that the edges were minimally cropped and it was shrunk. And the state can't conceive of a reason why a larger profile photo would make any difference.
Okay, let me understand.
Go ahead.
One more follow-up then. Let me understand that. So you're saying that the defendant's profile was only minimally cropped,
Yes.
and if that happened with with May's profile, then the photo, even the profile photo, wouldn't really have shown much of her face. Is that your point?
Yes, Your Honor. Her face seems to be almost entirely covered by hair with a small amount of chin.
And you're positing that that would have been true also with the bigger photo?
Yeah, it's like if Cam's photo was cropped that way, we can infer that May's photo was cropped the same way for her thumbnail.
As far as whether the photo would be exculpatory versus whether there would be any likelihood of it there being a different outcome if the photo had been available, it seems like one of the arguments that the appellant is making is that not necessarily on the age, that the age would have been so much different, but that we would have seen, or the jury would have seen how beautiful she was, and that would go to entrapment. Is the idea that rather than being 65 and showing an age difference, but if the photo were to somehow show beauty, or so to speak, does that go to it being exculpatory? Or does that, and then would we move on to the question of whether it would have made a difference?
No, Your Honor. It is clear from the chats that he believed she was 13, and no matter how attractive a 13-year-old is, you are still not allowed to meet up with them for sex.
I agree with you, so I'm asking kind of the narrow question though of does showing that she was beautiful at least go to the argument that it was more likely to be entrapment if the photo showed someone more beautiful?
No, because attraction does not show entrapment, especially in a child sex case where, again, no matter how attractive the child is, it is still a crime to try to meet up with them for sex. So the attraction of the model has no bearing here. And again, we have several other photos of what May looked like. So the jury was clear on what Cam saw when he was attempting to meet up with May.
I'm sorry to make you circle back, but because now we kind of moved to entrapment and going back to the destruction of evidence. I couldn't follow what the district court was doing on culpability of the state. Do you think the district court got that right? Because it seemed like when we're looking at the issue of culpability, it's like, was the picture destroyed accidentally? Was it lost in some sort of administrative error? Or did the state, just with full consciousness, destroy a piece of evidence? And here it seemed like the district court said that the culpability was minimal because first the photograph has been produced, and what that says to me is we're not capable or culpable because there was no destruction of evidence. And your briefing seems to concede that there was destruction of evidence. The second part, and I'm sorry that this is a multi-factor question and long, but it gets to the same part. The second part is that it really wasn't prejudicial, which to me doesn't go to culpability. It goes to the third element of whether there was prejudice by the destruction of the evidence. So those two things, I'm questioning whether on that point of culpability, whether the district court got it wrong.
No, Your Honor, the district court's wording is a little weird, but I interpreted that as the district court saying, not that they produced the evidence, but that they didn't destroy the evidence in bad faith because they preserved part of it. It wasn't, we need to get rid of this could show something. It was, we need to protect the CI, and we preserved enough. And I think that does go to the bad faith where the, yeah, and as far as the prejudice, you're right, that does go to the prejudice prong. A little separate, I do think the district court's wording was weird. But yeah, the officers did destroy the profile, just not in bad faith in order to protect the CI.
Thanks.
Next, Cam did not unambiguously invoke his right to counsel. In the video, it's clear that he was repeating his rights back to show that he understood. That's what the district court found below, and that was the correct finding. The officers are repeating the Miranda rights to Cam, saying, you have the right to an attorney. He nods. You If you cannot afford one, we pointed to, he nods. Then they say, do you understand these? He nods again, and they say, can you tell me so? The officer testified below that he was asking KM to repeat the rights back to show that he understood. And that's when he said, and they said, can you tell me so? And he said, I have to tell my attorney to talk to you to answer my questions.
Under one of the versions, transcript versions that we have, it looks like he said, after being asked, do you understand your rights? He says, wait, I have to tell my attorney to talk to you and answer my questions.
That is...
If they're really, some of the versions don't have the wait. To me, it seems like that could kind of make a difference. If someone says, wait, I have to tell my attorney to talk to you. And it kind of, and I haven't listened to the video yet, but it may turn on inflection on where the pauses are. But just reading it from the transcript, that does sound like, I need to talk to my attorney.
First, I believe that is defendant's own self-serving transcript. That's not the district court's transcript. And I encourage you to watch the video yourself. It is a little muffled. It sounds to me like he says that I have to tell my attorney to talk to him to answer my questions. Because again, they say, can you tell me so? And he kind of mumbles back that I have to tell my attorney to talk to you to answer my questions. It's sort of in that inflection. In the video, I didn't hear a wait. Defense argued that below in front of the district court, and in the district court's transcript, they did not include the wait. They seem to have also disposed of that argument.
Do you agree with counsel's answers to my questions about the standard of review here, and then what we do if we see differences in the transcripts? Can we go look at the video ourselves and make our own determination about what was said?
I believe the district court's findings are reviewed for clear error. However, where we do have a video, it is what the district court interpreted is clear as well, so you can go and watch the video yourselves and see what exactly he said. And again, in the video, it's clear he is repeating his rights back.
And I guess that flip side of the coin, though, if you say, well, he wasn't clearly invoking his rights, he was actually mumbling and we're not sure what he said, then how is it that we can then turn to those same words and say, well, see, that shows that he did know what he was waiving, when we aren't even sure what he was saying?
Well, first, the district court's finding was that he was confirming that he understood that he had a right to an attorney who can answer any questions that he may have. The only part that's mumbled is the that or the possible what at the very beginning. The rest you can clearly hear. But like I said, from tone and context, he's repeating them back. He may be paraphrasing his rights and not stating them exactly as they are in Miranda, but he's not a lawyer. He's nervous. He's talking to the police. Nothing in Miranda requires an exact recitation of your rights to waive. The officers ask him many times, do you understand these rights? He nods, he says yes, and then he continues to answer the court's question, or the officer's questions. And the court found below that he was not, he never expressed confusion. He indicated that he understood. That's the closest finding we have from the court that he understood, is that he indicated that he understood. And that is because this issue was only arguably preserved. The court's finding on that isn't as clear. But again, he nods multiple times. Do you understand? He nods, and he says yes when they ask if he understood his rights. And then he answered the questions.
Arguably preserved. Can you say more about what your position is on that?
Well, even if it's not preserved, as I explained, he understood his rights. However, below, counsel argued that he never waived his rights. And there's a difference between a valid waiver or understanding. They didn't say he didn't waive his rights because he didn't understand. Defense counsel below seems to have argued he didn't waive his rights because the cops bulldozed over him and kept asking him questions anyway and didn't wait for a valid waiver. And then below, the court held that Qayum indicated that he understood his rights, that he never expressed confusions, and those aren't explicit findings that he did understand his rights, just that he told the police he did. And there is like a little leeway there. Again, it's close enough that it doesn't need to be decided on preservation.
The state's okay if we go ahead and decide that one on its merits?
Yes, Your Honor. If the court has no further questions, we ask you to affirm. Thank you.
Thank you, Ms. Sopp. Ms. Scabine.
Thank you. Natalie Scabine again for Mr. Qayum. So the age that the woman in the photo looked is essentially a factual question, and in the Dickerson case, the district court made a finding that the woman in the profile photo looked older than 18, and that was important to the court's ruling in that case that there was entrapment as a matter of law, which, although that was reversed, the court understood that it was still an important factual finding, and that it was something that could be argued to the jury and would be important below.
Well, on remand, that you may not know this, but on remand, there was a bench trial, and the court actually made a finding that he didn't think she was over 13, even though the court made a finding that the photo looked like it was somebody in the mid-20s. So does that change your analysis there?
It doesn't, because it's still such an important part of the case. I mean, that was what the case was about, and it went back and forth about how it's going to end up and what the result is going to be. But in this case, where all we have to show for the destruction of evidence point is a reasonable probability that it would have been exculpatory, it was such an important part of that case, it would have been such an important part of this case if the state hadn't destroyed it. And the state talks about, well, if it had been clearly an older woman, then we wouldn't, then there'd be a reasonable probability. But again, here we have what is clearly an adult. So there's a reasonable probability that it would have been exculpatory. And the state talks about,
So I'm sorry to interrupt, but when we say exculpatory, does that mean it just kind of like relevance? If evidence is relevant, if it has any probability to influence the outcome, is it exculpatory if it has any probability to point in one direction?
it just has to be a reasonable likelihood that it is exculpatory. And as in De
But you
Jesus,
just used exculpatory to define exculpatory.
well, that it would have helped the defense. If all we can show is that, as in Muhammad, that there's no video and maybe it would have shown something totally unreasonable for it to show, then we don't get there. But in this case, we have enough where we know that the model was over 18 and we know from the later photos.
So if it just has to have any potential to help, as long as we know that the photo showed someone over 18, we'd say it's exculpatory or reasonable probability that it points in the defendant's direction, and then we move to the next step to say reasonable probability.
That's right. And then that next step includes a prejudice analysis. And in De Jesus, the court had said, well, because I just really don't think the video would have showed that, it's not prejudicial. And the Supreme Court said, well, no, it would have been so important to the case that once we pass that threshold of reasonable likelihood, there's actually a lot of prejudice here because it would have been what the defense focused on if they had that video.
What do you make of the,
I had one follow-up.
Yeah, go ahead.
Because of the question I asked your opposing counsel. Is part of your argument that if the photo showed that the model was beautiful, that also is exculpatory?
Yes, for entrapment. And we're not talking about a beautiful child here. We're talking about a beautiful adult model. And the officer testifies, I was looking for someone who looked young. Well, I think the jury can decide if he was looking for someone who looked young or if he was looking for someone that would get a lot of interest with an online profile.
What do you make of the state's argument made here today that we can look at your client's, how your client's profile photo, which we do have in the record, and how that was cropped down for the thumbnail purpose. We can see that it was only barely cropped, and the inference the state would like us to draw from that is that the thumbnail that we see wouldn't, even if we had the big photo, wouldn't have shown her face anyway.
So the photo of Qayum of Mr. Qayum was from far away. So when they cropped it down to a thumbnail, you still can't see much, but you can see him because it was from far away. Her photo was a close-up, and it's just not reasonable that if all he could see was hair, he would have been so interested in her. So I think there's a reasonable probability that the photo would have shown an adult, attractive woman who did not look 13.
Thank you.
Thank you. If there are no further questions, we ask the court to reverse.
Thank you both. We appreciate your briefing and your arguments here today, and we'll take the matter under advisement and issue a written opinion as soon as we are able.